The pages of history hold stories stranger than fiction, and today we bring you a unique chapter, the trials of animals in court. Join us as we delve into the quirky and unexpected cases where animals stood in the defendant's seat. Before we jump into these bizarre stories, don't forget to hit that subscribe button and ring the bell to stay updated with our unique content. Let's get started. Slugs. In 1487, the slugs of Auden faced an unusual response to their perceived threat of devastating crops. They were generously forewarned through 3 days of public processions, during which they were officially instructed to leave the area under penalty of being accursed. Similarly, the following year in Beaujeu, the slugs experienced a similar warning. They were told 3 times that if they failed to vacate the province, they would face excommunication. Despite the apparent absurdity of warning slugs, such proclamations served a legal purpose for ecclesiastical courts. It rendered the animals fair game to be killed. Surprisingly, even snails faced prosecution in different years: 1487, 1500, 1543, and 1596, all within the context of France. Unfortunately, the historical records do not reveal how snails were punished in these instances. The legal proceedings against slugs and snails during these periods reflect the curious intersection of folklore, superstition, and ecclesiastical authority, illustrating how the legal system was invoked in unconventional ways to address perceived threats or nuisances, even from creatures not typically considered subject to human laws. Dogs, unlike livestock, were treated differently in historical legal contexts. They were regarded more like people. Similar to women and serfs, dogs were included in the Wehrgild, which was insurance payable by their killers to their owners. In Old Germanic law, dogs, along with cats and cocks, could even serve as witnesses in court. For example, if a dog was the only witness to a burglary in its owner's house, the homeowner could bring the dog to court, accompanied by 3 straws from the roof thatch symbolizing the house. However, engaging in sexual activities with dogs was considered as reprehensible as having intercourse with a Jew, according to Christian sensibilities. In a historical case, a Parisian man was burned alive for coition with a Jewess, or sodomy, with the court equating it to the severity of copulating with a dog. In another instance from 1606, a man from Chartres faced a hanging sentence for sodomizing a dog, but he managed to escape before the execution. Instead of killing the perpetrator, authorities hanged a portrait of him in his absence. Despite these harsh examples, not all legal consequences for dogs were fatal. In 1712, for instance, a drummer's dog bit a councillor in the leg, resulting in a 1-year imprisonment sentence in the Nerenkoder line, an iron cage placed over the marketplace. These historical accounts reflect the complex and sometimes contradictory ways in which dogs were perceived and treated within legal systems of the past. Cows. Due to their size, weight, and temperament, cows were occasionally charged with a tax in historical legal contexts. In 1314, for example, a bull escaped from a farm in France and fatally gored a man. The bull was subsequently captured by the Count of Valois' men, imprisoned, and even sentenced to hang. However, since the Count had no jurisdiction in Moissy, where the incident occurred, the sentence was overturned, albeit after the bull had already been killed. There are numerous other instances of cows deemed responsible for fatal attacks being sentenced to hanging. However, due to the considerable value of cows and bulls, as well as horses, they were often confiscated instead of being executed. In 12th century Burgundy, laws explicitly stated that if an ox or a horse committed homicide, it would not be condemned to death. Instead, it would be taken by the feudal lord within whose jurisdiction the incident occurred, who could then sell the animal and keep the profits. However, the laws also included a discriminatory clause, stating that if other animals or even humans, specifically Jews, committed similar acts, they would be hanged by the hind feet. In general, animals that were executed, including the organic grass-fed cows of the pre-industrial era, were not consumed as meat. Once an animal had reached a level of blood guiltiness comparable to a human, it was deemed inappropriate to eat its flesh, as it would be reminiscent of cannibalism. Exceptions existed, such as a cow killed in Ghent, Belgium, in 1578, whose flesh was sold to compensate the victim. Nevertheless, her head was impaled near the gallows. These historical accounts provide insight into the peculiar ways in which animals were treated within legal systems of the past. Termites. When the Portuguese invaded Brazil, they brought along a peculiar legal dispute that involved charging termites with vandalism. The plaintiffs in this unusual case were Franciscan friars, followers of a man who, 5 centuries earlier, preached sharing and kinship with animals. However, the friars sought to excommunicate the termites for eating their food and damaging their furniture. Interestingly, the defense lawyer in this case resembled St. Francis more closely, arguing that the termites, like all of God's creatures, had a clear right to sustenance. The defense even claimed that the industriousness of the termites put the idle Grey Friars to shame. Additionally, the defense argued that the termites were on the land first. The trial concluded in January 1713 with a compromise. The friars agreed to set up a reservation where the termites could live undisturbed. The decision was communicated to the termite mounds, and according to the account, no sooner was the order of the prelatic judge promulgated by being read officially before the hills of the termites than they all came out and marched in columns to the place assigned. This was interpreted as proof of their submission to God. This unusual legal case provides a glimpse into the blending of cultural clashes, environmental issues, and religious beliefs during the period of colonial expansion. Pigs. Pigs were frequently subjected to prosecution, and one of the primary reasons for this was their tendency to roam around towns without supervision, consuming whatever they encountered, including consecrated wafers and, disturbingly, even children. There are numerous historical examples of pigs being prosecuted for the latter offense, and the usual punishment was hanging. In 1567, for instance, a sow with a black snout was hanged from a tree for devouring a 4-month-old child's head, left hand, and upper chest. In some instances, the punishment was considered proportional, following the principle of an eye for an eye. For instance, in 1386, a pig that had attacked a child, tearing off the face and arms, was sentenced to hang after being mangled and maimed in the head and forelegs. The pig was even dressed as a man for the occasion. Another gruesome punishment involved burying pigs alive, but more commonly, they were burned alive. Some judges, however, displayed a degree of mercy, ordering that the pigs be only slightly singed before being strangled to death, after which their corpses were thrown on the fire. Similar to other animals like dogs and cows, pigs were often imprisoned before facing execution. This imprisonment sometimes lasted for weeks, and they were held in the same jails as humans. The historical accounts reflect a complex and often brutal relationship between humans and pigs, with the legal system imposing severe penalties for their perceived transgressions. Woolly bear caterpillar. In 1659, an intriguing legal case unfolded when 5 Italian communes filed a complaint against caterpillars for causing extensive damage to their crops. The summons for the caterpillars to appear in court was quite unique. It was nailed to trees in the forests. Despite the fact that the caterpillars did not make an appearance at the trial, the court conceded that they had the same rights to life, liberty, and the pursuit of happiness as humans, as long as their pursuit of happiness did not infringe on the rights of humans. Even more surprisingly, bees found themselves facing legal consequences. In the year 864, the Council of Worms, referring to the Rhineland city, not the species, sentenced a beehive to be suffocated. This punishment was deemed necessary as the hive was held responsible for stinging a human to death. The sentence required swift action to suffocate the hive before it could produce any honey. The rationale behind this was that, due to the perceived murder, the honey would be considered demoniacally tainted and unsuitable for Christian consumption. These historical anecdotes provide a glimpse into the peculiar ways in which legal systems were applied to the animal kingdom, attributing rights and responsibilities to creatures in a manner that sometimes mirrored human legal proceedings. Donkeys. In historical legal proceedings, animals were occasionally granted the right to appeal, much like humans. An example involves a donkey that was initially sentenced to hang. However, an appeal to a higher court spared the donkey, and its sentence was commuted to a blow on the head. Appeals could even lead to acquittal. In 1750, a donkey faced condemnation for allegedly seducing its rapist. However, the animal was acquitted when the parish priest of Vanvers provided a certificate attesting to the donkey's good character. The document, signed by the priest and other reputable parishioners, stated that the donkey was in word and deed and in all her habits of life a most honest creature. On a darker note, another instance involves a mule that faced a harsh fate. Having been raped by a man, it was sentenced to burn at Montpellier in 1565. Moreover, because the mule was deemed vicious and inclined to kick according to court records, the executioner, in an extrajudicial act, decided to amputate its feet before burning. This unauthorized mutilation led to presumed scolding for the executioner, as courts disapproved of any additions to the sentence by their officials. These historical accounts highlight the curious and sometimes absurd intersection of animal and human legal proceedings in the past. Weevils. In a peculiar historical case, weevils faced legal scrutiny after ravaging vineyards in a French hamlet. The trial, concluded in the spring of 1546, featured the judge ordering locals to seek mercy from God, acknowledging that the earth was created for all of God's creatures. The hamlet also conducted 3 masses, accompanied by solemn processions and supplications around the vineyards. This unconventional approach seemed to work, at least temporarily. 40 years later, the Weevils returned, prompting a second trial. This case was brought before the Prince Bishop of Maurienne and his vicar general and official, recorded on 29 folia with a lengthy Latin title. The trial spanned several months, with the argument that people were guilty of incurring God's wrath since weevils had the right to eat plants. The defense emphasized the absurdity of applying human laws to insects. However, the vine growers, acting as plaintiffs, insisted that weevils were subject to human authority. The case experienced repeated adjournments as each side deliberated. The Weevils' legal team eventually countered that even if the insects were subject to human authority, it didn't grant the right to punish them, especially with excommunication, which was deemed God's prerogative. 2.5 months into the trial, an order was issued for the people to set aside land for the weevils, fenced off to allow them to live in peace. However, this solution proved ineffective, and 1 month later, the case returned to court. The plaintiffs requested the judge to order the weevils to return to their enclosure under the threat of excommunication. The defense argued that the enclosure was too barren and lacked sufficient food for the insects. The case experienced numerous adjournments, and it took another 1.5 months for a verdict to be reached. Unfortunately, the final page of the court records was eaten by weevils, leaving the outcome unknown. Monkeys. During the Napoleonic Wars, a peculiar incident occurred when some English individuals discovered a monkey on a beach. The context added suspicion to the monkey's presence as it followed the wreckage of a nearby French ship, and the monkey was the only survivor found washed ashore on debris, appearing soaked through and miserable. Lacking direct experience with French people and influenced by propagandist caricatures, the English assumed the monkey was a Frenchman. Compounding the misunderstanding, the monkey was dressed as a human sailor, serving as the French ship's mascot. Hastily conducting a trial on the beach, the English found the monkey guilty of espionage, sentenced it to death, and hanged it from the mast of a fishing boat. While this act was extrajudicial and a form of mob law, it was unfortunately not uncommon for people to take matters into their own hands when punishing animals. Disturbingly, an alternative theory suggests that it might not have been a monkey hanged but rather a child employed as a powder monkey responsible for priming cannons with gunpowder. Regardless of the true circumstances, the people of Hartlepool, where this incident occurred, are still known as monkey hangers today. Surprisingly, they have embraced this moniker, with their football team's mascot named Hangus. Rats. As recently as the 19th century, peculiar legal measures were taken against rats. Rats were served a writ of ejectment or a letter of advice to encourage them to vacate a house. To attract the rats' attention, these documents were often rubbed in grease. An example from Maine expressed sympathy for the rats, advising them to leave one address for another, offering the alternative of residing in a cellar full of vegetables or a barn full of grain. The letter concluded by warning the rats that if they refused to leave, they would face extermination with poison. In the 1500s, rats faced a legal summons in Autumn, a French province, for consuming all the barley. Recognizing that the rats wouldn't appear in court, the judge planned to punish them in absentia. However, the defense lawyer argued that a single summons was insufficient due to the large rat population in Autumn. It could never be seen by all the rats. Reluctantly, the judge agreed and ordered a second summons to be proclaimed from the pulpits of all the parishes in the province. When the rats still failed to appear, their defense lawyer argued that the presence of cats along the route made the journey too dangerous for the rats. This claim asserted the rats' right of appeal, allowing them to refuse to obey the writ. These historical anecdotes offer a whimsical glimpse into the imaginative legal proceedings involving animals. And there you have it, folks. The wild world of animals facing justice. Who would have thought? If you enjoyed this journey into the unexpected, give it a like and share it with your friends. If you haven't subscribed yet, what are you waiting for? Hit that subscribe button and join our curious community. Until next time, stay curious and keep exploring the extraordinary.